Good afternoon. My name is Jan McDavid. I'm at Hogan and Hartson here in Washington, D.C., and this afternoon it's my pleasure to interview my friend Phil Proger of Jones Day, also of Washington, D.C. Phil was my predecessor as chair of the ABA Antitrust Section, and we've worked together a great deal. Phil, tell me, how did you first become interested in antitrust law?
Well, it seems like a short time ago, but really isn't. After undergraduate, I had started in graduate school, but it was during the Vietnam War, and I didn't get to finish, and went briefly into the military. And when I got out, I decided maybe to do something that would make a difference or a change, so I went to law school. And after my first year of law school, what I discovered was what I was really interested in is sort of the subjects that got me into the economics and the how businesses worked that I had studied at undergraduate. So I took a chance applying for a summer internship at the Federal Trade Commission in 1972, got accepted, and this was just when Miles Kirkpatrick was reinvigorating what was called the old lady of Pennsylvania Avenue, and it was very interesting, and I really liked it. So at that point, after my second year in the summer at the FTC, I was pretty committed to looking at antitrust, and when I was looking at law firms, I looked at law firms that had an antitrust practice.
And where did you go to practice?
I started off, although I'm a native Washingtonian, I wanted antitrust. Let me step back. Was very different in those days. In every major city in the country, there was one or two or three law firms that had a pretty significant antitrust practice, which was a very litigation-oriented, some agency enforcement, but it wasn't Washington-centric at all. And Washington was viewed as more of an administrative practice, and I wanted to be, quote, in the trenches doing litigation, and so I went to a law firm in Cleveland, Ohio, which had established antitrust practice, and there's a little bit of a story behind that, which is a partner in that law firm had been an assistant general counsel of the Federal Trade Commission when I was a summer intern. And they had made me an offer coming out of law school, and I turned it down. He called me up the next day and said that he really wanted me to fly back to Cleveland and to talk to them because he really wanted me to come. And Jan, of course, you've known Lois, my wife, for many, many years, and you know that she's clearly the better half. So I went home, and John Ferguson, who's now deceased, but may he rest in peace, had sort of harangued me all day, and we were so poor that I didn't have the money to get a ticket to Cleveland, so they arranged for a ticket to be picked up at the airport. And also, there was a problem. I only had one suit, and it wasn't clean. But Lois said to me, "I think you should go to Cleveland. I think you ought to accept their offer." And I said, "Why?" And she said, "Look, you're not that great. Here's one firm that really wants you. You ought to take it." So I flew up there, and I got there, and they had someone meet me at the plane, and when I walked into the office, I said to John, "I've been thinking about it. I'm going to accept the offer," and he got real mad at me. He said, "I got this whole day planned to convince you. You got to go through it." So that's how I started.
And did you start right out in antitrust?
I did from almost instantaneous to my joining the firm the following May, which is what you did in those days. We didn't get paid not to come to the firm. And you took the bar review. The firm hired Alan Ward, who had been director of the Bureau of Competition in Washington, and within a few days of me joining the firm, the then largest vertical merger in the history of the United States, Fruhoff's acquisition of Kelsey Hayes, came in, and I was immediately put on it. Interestingly enough, the first project I ever worked on for the first billable quarter of an hour I ever did was for a company called Hancor, which was based in Findlay, Ohio, that extruded polyethylene pipe. And I later on not only worked for that company, I ultimately became its general counsel and on its board of directors, and stayed with it until we merged it into a bigger company 5 years ago.
Well, tell me about the Fruhoff case.
Fruhoff was a maker of truck trailers, and Kelsey Hayes was another Detroit company. And Kelsey Hayes had what was then one of the first hostile takeovers And so it looked around for a friendly white knight, and of course it looked to its fellow Detroit company, Fruhoff, which was a customer. Kelsey Hayes sold braking systems, anti-skid devices, rims, wheels, and et cetera to Fruhoff. At that time, it was the largest single vertical merger in the United States, $300 million, so, which today
wouldn't be lower mid-market.
Yeah, wouldn't be classified as much. And also, this is pre-HSR, so the deal went through, and then the government started an investigation, and I ended up working on that case for 11 years, including a full administrative trial, which we lost, to the commission, which we lost, and then ultimately an appeal to the courts of appeal, and we won.
So the merger had been closed for 11 years by the time the matter was over?
Correct.
That's amazing. So what did you think about Hart-Scott and pre-merger notification as a consequence of having lived through an 11-year proceeding in a closed transaction?
Well, actually, that's tied into how I got involved in the section.
Okay.
Because when I first started, one of the things that was really clear to me was that, you know, every firm sort of had a practice, and it was Cleveland. And of course, Cleveland in those days was the third in corporate Fortune 500 companies headquartered there. So all the major firms there had an antitrust practice, and there was some local. But I was aware of the ABA Section of Antitrust Law. And, you know, people have different reasons, but when I had been at the Federal Trade Commission, a lawyer by the name of Jerry Tinsley had said something to me that had stuck in my mind, which is, get involved in the Section of Antitrust Law, not for the networking, not for any of those things, but to get exposed to new approaches to different ideas. And you and I have talked about at times how we do things differently, and, you know, and I've tended to learn from that. And so I was very much of the mind I should join it to hear how other people did things differently than we did it in Cleveland or we did it in the law firm. And in those days, you couldn't just join the section. You had to get appointed by the chair. So I dutifully wrote, there were no emails or anything like that, we wrote letters with carbon copies, yellow, pink, depending on where, and I didn't get an answer. I didn't hear for months, and there was a lawyer, Bill Falsgraf, who later became president of the ABA, that I ran into and knew, and he was an environmental lawyer, and he told me to get active in the ABA, and I told him I'd been trying. And then I heard back, and the result of his intercession was I got appointed. And I had written, I had to write the letter again. I had written that there were 3 committees I was interested in, and one was the Section 7 committee, which is mergers. And I got appointed to that, and I dutifully wrote to the chair of that committee and volunteered to do some work and heard nothing. And so this is many discussions about this Jan and I have had over the years of getting younger lawyers involved.
And how anxious we are to have younger lawyers involved.
I know. But since my family was in Washington and there was a reason to, on my own, I went to the first spring meeting that I went to in 1974, went to the meeting, which was at the Shoreham, and had recently moved from the Mayflower on Connecticut Avenue, was now at the Shoreham, was much smaller. And the Section 7 committee had its meeting, you know, on Thursday morning at 8 o'clock, and I was one of 7 people in a room. There was no agenda, there was no program, just sort of talked about things. And afterwards I asked the chair of the committee if there was anything I could do, and he said no. So, but the incoming chair was Eleanor Fox of Simpson Thacher. She hadn't started, I think she may have been an adjunct at NYU. And Eleanor was wonderful, and she got my name and number, and a few weeks later called me and said, there's some new legislation being proposed about notifying mergers earlier, and I have to prepare a report for the section and to the council. And ultimately she had to testify in Congress. And I ended up working on that legislation and helping her with the background papers. And my first part that I did of HSR, which is a trivia part, was the original bill said that if the FTC or DOJ certified it was in the public interest, the federal Article 3 judge had no discretion. He or she had to issue a TRO PI and enjoin the merger pending the administrative process. I thought, from a constitutional standpoint, being still a law student, forget antitrust. From a constitutional standpoint, you couldn't do that, and we wrote that up, and eventually that went out of the bill, and Eleanor kept me involved, and that's how I got involved in the section, was through Hart-Scott-Rodino.
So what were your other projects as a young member of the section?
So that was in 74, having started practice in 73. In 1976, the section had started the monograph series. And Dan Kolb, who had succeeded Eleanor, Dan from Davis Polk, and was very helpful to me and very open and like Eleanor, encouraging younger lawyers, asked if I would be deputy chair under Tom Dietrich of Sherman and Sterling to do that monograph. And that is, it's merger standards, it's the third monograph, and I basically spent hundreds of hours working on that. And you know, we had young kids, and I'd go into the office in Cleveland on a Saturday and get my law review type Carol that all the library had with all my books and things, and spend from 6, 7 a.m. Saturday to 5, and do it again on Sunday working on that. And we had a committee, and we produced the monograph. So that's how I sort of really got started.
Did Eleanor serve kind of as a mentor to you in the antitrust section?
Eleanor was wonderful, because Eleanor would take the time to talk to you and explain things to you, and you know, she's always had that teaching instinct, and she was open to having younger lawyers get involved and be. She was supportive of your interest, and she made time available.
That's terrific. So what was your first official position after finishing the monograph?
I actually, at the section meetings we're having, had lunch yesterday sitting next to Harvey Applebaum, and he was, in 1980, he appointed me to be vice chair of the Section 7 committee in a day when there was the chair of the committee and just vice chair of the committee. So that was my first appointment, although Harvey told me yesterday that I'm still on double secret probation, so, which I told him I thought was warranted. So.
And did you eventually become the chair of that committee?
I did. The chair of the committee was Steve Axon at Skadden Arps, and you know, Steve had legions of people that worked with him. I was actually still an associate at this point, and then after the first year became a partner at the end of that year. But I didn't have minions of people that I could devote on matters, and Steve would say, we got to do this, this, and this, and Bruce Prager was sort of his assistant at the firm, Prager and Proger, and we'd get on the phone, and you know, I'd say to Bruce, you know, you got 20 people there can help you. It's just me. So, but Steve was a good chair. He was very active, and we did a lot, and we were very active. And then I did succeed Steve as chair of that committee.
And at some point, you got active in other committees in the section. I remember this.
Right. Well. When I was in my last year of the chair of the merger committee, I got a call from Jim Rill, who I knew but I hadn't had a lot of interaction with, and he said, can we have lunch over at the Metropolitan Club? And so I said, sure, and we scheduled it. I told Lois, this can't be good. So we went there, and he said there had been some talk among the kind of the senior leaders of the section, and that there was a committee that was rapidly growing on healthcare antitrust, because in 1976, 1977, there had been a series of Supreme Court decisions that had sort of opened up healthcare to antitrust. And now this is
Maricopa County.
Maricopa Rex Hospital,
right.
The Bates advertising case, and the learned profession exemption had been knocked out. So this is 10 years later, and the section had started a healthcare task force and then a committee, and now the committee is like 400 members and really growing. They felt that they were getting a lot of healthcare lawyers into it, which I think is great, and the section thought was great, but there wasn't a lot of necessarily antitrust expertise. And so Jim said, so what they would like me to do is go over and become chair of the healthcare committee, and they were also going to help me with some appointments and things to get more of antitrust lawyers in the leadership of that committee, which they were very excited and happy about, but felt was more healthcare lawyers within the antitrust section. And at the end of the lunch, she said, "Oh, by the way, there's one thing I should mention to you, which is Sylvia Walbolt, who's a wonderful chair of that committee and was a wonderful chair, and I enjoyed working with her, has one more year to go. So you're going to go from being chair of the merger committee, which was a pretty important committee, to being it wasn't vice chair, because they didn't have vice chairs. They had subcommittees, one of 3 subcommittee chairs, right?" And I said, "Oh, okay." But I did, and they were true to their word. At the end of that, I got appointed to be chair of that committee. And the incoming chair who made the appointments was a partner of Roxanne Busey, who, of course, later became chair of the section, and called me up and said, "I'm going to do a big favor for you. You're going to be chair of the committee now." And I had made a recommendation to eliminate the subcommittees because they didn't make sense, and to just have now 2 vice chairs. And he said, "I'm going to make Roxanne one of your vice chairs." And that was also godsend, because it turned out Roxanne was wonderful and a great vice chair, and later succeeded me as chair of the committee. Right. And we did a lot of new things. We started the committee newsletter called The Chronicle, and invented that name and some other things. And so I did that for what was 4 years. 1 year as the subcommittee chair and 4 years. And Real had previously said that I was too young to go on the council, but at the end of this, I would be good to go on the council, and I don't know if he engineered it or what the deal was, but I then went on the council.
Now, while you were chair of the healthcare committee, don't I recall that they wrote a couple of books? We
wrote, because we had such good people and Roxanne was so good, we ended up having, the Chronicle come out quarterly. We started the publications and really ramped it up, and we did in those 4 years over a dozen publications of one sort or another, really due to the expertise and competency of a lot of other people. But my sort of thought, a little scarred by my own experience of joining, was I had a policy that anyone could propose a project, and if they wanted to do it, as long as they submitted an outline and we had quality control, you could do it. So and the committee had now gone to like 500-600 people. We had all kinds of projects going, and I felt, that's great. That's getting people active, and I was really blessed by having Roxanne and 2 other vice chairs. By that time, we ended up with 3 that were very good. Kevin Grady got to be one. I mean, it was all future chairs of the section that came out of there, and so I'd get them to supervise and oversee. But basically, during my time as chair of that committee, if you proposed something and wanted to do it, you could do it and set up a task force. And we had at one point like 20 task forces going, and half of them or so came through, and we had a lot of publications.
I think I remembered programs that were healthcare oriented in that time for the first time for the section.
We started the first program. We actually had a 2-day program that was greatly attended, and we got programs on at the spring meeting and other programs. So it was a very active committee. People were very enthusiastic, and because it was, a new industry in the United States, but the largest industries in some respects of the United States, people were excited, and there were a lot of new things coming around, and there was still ongoing battle of what the parameters were of where antitrust and healthcare and the various issues you confront with regulatory intrusion, et cetera, where the boundaries were. So there was a lot of things to talk about.
Now, did you develop a practice in that area as well?
The firm had a tax-exempt practice. The former head of that section at the IRS had become a partner of the firm, and he had come to me in 1976 with a hospital that had been sued by some physicians for antitrust, which was unheard of because, one, it was viewed that they were not in interstate commerce, so they weren't subject to that. The physicians were viewed as being part of learned profession and might not have standing, et cetera. So I got this, and I'm a third-year associate, but he knew I was an antitrust associate, and this whole start of my career was happenstance because I happened to be walking past his office when his door was open when he was on the phone and he screamed out, come in here. He didn't even know my name. His name was Bob Romberg. He's now deceased. And got in there, and he was on the phone with his hospital administrator, and here he's a tax-exempt lawyer, and this guy's talking antitrust. He said, oh, here's one of our antitrust guys. And so this guy's talking, and of course, I first said, well, I don't think they can do that, because this, and this. And they said, good, so it's your case. And I won the case, so that made me an instant expert.
And a hero.
Yeah, and a hero. Very few times in my life.
So then, after your term as chair of the committee, you went on the section council. And what was it like to be on the council? And when was this? What year?
I went on the council. Well, that's a good question. I started in 1980. I think I went on the council in 88 or 89.
Okay.
So, being a chair of two committees, particularly active committees, I thought was a great job in the section. And different chairs had different philosophies. Some chairs really like to get face time before the council. I viewed the council as sort of an evil that could interfere with what I was doing. So I avoided going before the council at all costs, and even on some occasions sent Roxanne or others, and pretty much did what I wanted, and the committee was active in producing things, so the chairs were happy and we weren't a problem. You go on the council, and now you're part of a larger group, and you're not responsible for doing anything or involving things, and as a consequence, being on the council was not my favorite thing in the section, because it wasn't a chance to really do things. So.
Well, what I found was most of the decisions were made at the officers' meeting the afternoon before the council meeting, and then they were kind of ventilated with the council the next day.
Yeah, but we continued that tradition.
We continued that tradition when we became chairs.
When we became chairs and officers. So.
What was your progression after your term on the council?
Well, I should mention Tom Rash. Tom was one of the chairs during the 3 years I was on there, in my second year, and we were having a difficulty with the membership committee, and he asked me to get involved. There was someone else who had been responsible for it, and it had sort of not gone anywhere. And he asked me to work with the vice chair of that committee to see if we could get that going, and why the committee was seemingly in a downward spiral. And that was, frankly, for someone who wanted to be active, that was sort of nice, a chance and something to do. And it was also fortunate because that vice chair was Sarah Vance, the Honorable Sarah Vance, now United States District Judge in Louisiana, and also a wonderful person. I mean, I'll digress. I mean, the great thing about this section is there's so many great people that you get to know and meet, and so talented and smart. And of course, Sarah blew me away, because she wasn't a judge then, but she already was a judge. She was totally together. She was organized. She had everything. She was smart. And I remember I met her, and we sat down. I think it was at a spring meeting, but it was face-to-face after having a telephone call, because, again, you didn't have emails and things like that at this point. And boy, she vented. She was very frustrated. She was trying to do a number of things, and the then chair of that committee, who can be nameless, was just standing in the way. So I went back to Tom, and I made some recommendations, the first of which was to replace the current chair with Sarah, which we did, and things immediately changed. And that was a chance to at least, to do some things. And then when I was done with the council, I was nominated and became finance officer, which was a story unto itself, because, as you know, we
didn't have any money.
Well, I went. Jim Halverson mentioned this to me yesterday at the past chairs dinner, but I went to the first section officers meeting. For those who don't know, that in the fall, in September or October, or usually late September, there's a meeting of all section officers, and you meet not only by your antitrust section, but you meet by type of office. So I met with the other finance officers. And at the end of that meeting, the then ABA controller, Beverly Armstrong, asked if I could stay over for a few minutes. And she said, I understand that you're the new budget officer. She called it budget officer. We call it finance officer for the Section of Antitrust Law. And I said, yeah, I am. And she said, look, I'm glad. I'd really like to help you. but we got to start off with an understanding here. And I said, okay, I mean, I could use any help I could get on, et cetera. I'm not aware of all the issues, but fine. And she said, you're broke. You have no money. And if you don't clean up your mess, we're going to step in and we're going to take over your finances. And I said, I don't think you can do that. She said, oh, yes, we can, because you're actually not an independent entity. You're part of the big ABA. And then she said, but look, we can avoid this. Let me help. So I went back and dutifully reported this to the chair and chair-elect, and the chair was Mike Denger, and the officers, and everyone was alarmed. And so he created a task force that I chaired, which was to reduce our expenses immediately. And in quick order, we eliminated all soft drinks at programs, meetings, etc. All you could get was coffee. A soft drink in those days was, even in those days, it was $1.50 a setup. At our meals and what service, etc., I told the then person who ran our meetings that they had to either eliminate salad or dessert. We changed the paper in all our publications and went to, I don't think anyone ever noticed, but a lower grade paper to save money.
And we eliminated reimbursements.
The big thing was, at that point, there was a per diem of $75 a day for anyone who attended the section leadership meetings, as well as a lot of people got airfare. And we did keep airfare for government lawyers and for academics, and for people who had special needs had the right to go to the finance officer with the chair on a confidential basis and get reimbursement, and only the staff, and you knew that. But everyone else, reimbursement was eliminated. And, the big ABA at the end of the year was very complimentary. We had a surplus, and we continued that for many years and started publishing more and running up actually pretty big surpluses. But there was a time when it was sort of touch and go. So, and no one was pleased with me for eliminating soft drinks at meetings.
We've put them back since.
I know.
Now that we have a surplus.
Mistake in my mind.
What was your next position in the section?
Let me think. After finance officer, I became publications officer, and set up we always had a publications chair, but I saw two discrete tasks here. One was the editorial function, and the other was the production function. And so, as publications officer, I changed that around and created two chairs. One who did the editorial and ensured quality and et cetera, and the other who made sure we worked with ABA publications to get the publications out. We didn't have any spreadsheet or schedule of when things would come out. We had no input into committees on why their publications were late or behind times or where they were in the cycle. There was no thought about whether you got things out for the spring meeting where there were big sellers. The only publication that, frankly, at that point was really paid attention to was Antitrust Law Developments, which admittedly is our premier publication. But we put in a schedule, we put in a tracking system, we put in a number of things. And I was really mindful that we shouldn't control the process in the sense of telling the committees who were generating the content what they had to do or not do. But if they were going to do it, they had to be on some schedule, and we had to know how they were going to do it. And we pointed out to them when would be a good time to get it out. And we had a number of publications in those years that sort of didn't go anywhere, flopped, because by the time we got them out 2-3 years later, they weren't timely. And we worked very hard at eliminating that and getting things out. And I think in the 3 years we published more than 10 publications a year. It was over 30. So, and again, not being falsely modest here, it was really due to the work of the people below, Rob Walters and others that really did a great job of working on those publications and getting things organized.
I recall we managed the process.
Yes.
I think it was when you were finance officer that you and I became good friends.
Yeah, well,
and
it was a trip.
It literally was a trip. We were going to the ABA annual meeting in Atlanta.
Right. Actually, Jan and I were talking about this before. This is like out of what Gigi, he said, she said. I thought it was New Orleans. I'm sure she's probably right and I'm wrong. But we ended up getting sort of stuck on a plane together. We were late or something, I don't remember exactly. And we got down there too late to go to the various festivities, and so we ended up having dinner, just the two of us in a restaurant down there, and we got into a discussion about the section, and how should I put this? Jan opened up my eyes, and I think you can talk about this. I was literally very surprised about the section's openness to new people, to women, minorities, you know, I think you can always talk the talk. It's different whether you walk the walk. And it was a very interesting conversation because some of the thoughts you had and observations and things that you were aware of, I was just oblivious to. And in hindsight, they were probably in front of me, and if I had thought about it, if I had been conscious, you know, I probably would have caught it, but I was totally, as you recall, surprised.
But and you began to walk the walk.
Yeah. I think I was so surprised that I called you afterwards and said, could we get together back in Washington to explore this, because I was still a little incredulous that some of this existed. So.
But that was the beginning, I think, of the section being really open to providing opportunities for women and minorities.
Right. I don't think it was me. I mean,
but it was at that time.
Yeah. I mean, I think the section was changing. Bob Taylor certainly did something with Mary Cranston, and of course you were getting active, and Roxanne, and there were other very qualified, competent women, and we still were not doing a very good job on minorities, but we were starting to do a better job. But still, we had a ways to go, as I found out.
Well, you eventually became the chair of the section.
Right.
In 1997, 8?
No, I was 98, 99 chair,
and I was
and you
90,
were 99,
2000. Yeah.
You should know. And I had 1 year as vice chair, at a time when vice chair didn't mean anything, because I got parked for a year because we had Jim Loftus and Bob Weinbaum. Then when I became chair of the section, I did several things that I think have still lasted. One was, at the SOC, I had come to observe that we always were getting outmaneuvered in sort of the internal big ABA when we would come up against a certain section where you sort of had intersecting interests, like admin or litigation, and there had come up now a healthcare committee, which now is a section. And part of it was that our process was you didn't know you were going to be chair-elect until very late, and then you became chair-elect. Well, every other section, all the big sections, had a longer succession ladder, and there was vice chair, chair-elect, chair, and then immediate past chair, and then chair of the membership, the nominating committee. And I thought having that extra year where you were in the SOC and getting to meet the people that would be chair when you were chair of other sections might facilitate working things out if you had to and knowing people. So I proposed that we actually in those days had 2 vice chairs, that I proposed eliminating those positions and creating 1 vice chair, but election to that vice chair meant you automatically succeeded to chair-elect and chair. And that's the way we do it. And so.
Well, one of the initiatives that I recall was that you started, and I continued, outreach on an international basis, because we were very inward-looking, very U.S.-oriented.
Yes, and I think, you know, we should be clear that when I was chair, I mean, we worked very closely together, and I was very much aware of the latter, so I wanted you to be aware of everything going on. So I shared everything, and I didn't really think that we traveled together. I didn't think it really meant a difference who was chair or chair-elect, because, you know, you and I have talked about this before. I see, this is from my being a trustee of a Catholic hospital system, I see it as a 1-year stewardship. You don't really own it. You're just a steward, and it isn't about you, it's about doing that. And so we talked about it, and one of the things we were noticing was the growth of the International Bar Association, the IBA, and that they were coming in and doing some things. And we were doing more and more international things. But the overall driver was antitrust was becoming international. And when it might be rare, once or twice a year, you'd have a matter and have to go overseas to talk to a foreign client, Now we were starting to go overseas several times a year, or once a month, because matters were coming, and the United States and the European Commission were cooperating. And this is at the time when competition regimes are proliferating. So we recognized that, and we reached out to the IBA, to Bill Rowley, and to Michael Reynolds, you and I, and we gave them sort of observer status at our council. And we got similar, and we went to their annual meeting in Vancouver. Right, where you took me on a nice day the day before on a big tour of the big park there.
Stanley Park.
Stanley Park. It was a big hike. And we really reached out, and then you really continued it and advanced it much further than I did, but it was a start.
Now, how is the section different today in your perception than it was when you became active?
Well, you know, I love the section. I think the section's a great institution. I think I have a perspective, as you know, about where the section fits into the big ABA and other sections, and I think it is probably, in my mind, the single largest conglomeration of talented people that I've ever been associated with, and that continues. But I think there's a lot of changes going on. The section is smaller in actual numbers, because when we were there, it was as large as 13,000 and then got down to 9,000. But it has got more people in the leadership. It is larger in that sense. It is more active in that sense. The spring meeting is 2,500, which is by 1,000, probably larger than it was when we were chairing. And I think it is, in that respect, phenomenally different, impressive. But the single biggest change in the section is technology and the real information you get from the section on a daily basis that's instantaneous. If you're an antitrust lawyer, I think the section is sort of indispensable, because from its listservs, its brown bags, its webinars, I mean, in my firm, and I know you do the same thing, we encourage all our new lawyers in the practice to join the section and become active, because there's so much resources that are available from the section. And we didn't have that. The section has really developed that in the last 5 years.
Well, first of all, it was on paper.
Well,
everything we had was paper.
Right. I mean, we didn't have the technology to do it.
Yeah.
Right. And the other consequence is everything's instantaneous. Everything is much faster, because everyone's getting everything out today. You know, I mean, I was looking on the listservs, and there's already a lot of talk and communication about the new merger guidelines, which came out Tuesday. Today's Thursday. You know, when the other merger guidelines were on, I worked on a specially convened task force to come out with comments on them. And there were a number of us, Mike Dinger, John Briggs, and a number on that. And I think we got it out in record time, 3 months.
Exactly. So
today it would have been 3 hours.
There's already been commentary.
Right.
And the task force that's been formed will produce comments in the 30-day comment period.
Right. So
they had their first call today.
Oh, they did? Okay.
They did.
Okay. You're ahead of me.
After your time in the section, did you remain involved in the American Bar Association?
Yes, I went on the Board of Governors, because the sections get a representative, and I went on and I spent 3 years on the Board of Governors. So I know where you're going. The Board of Governors was a different experience. I mean, in some respects, you really get spoiled by being in the section, because the section is such a wonderful organization. And one thing about the section is that, for reasons that probably are historical because they predate us, not all, certainly not all, but many of the leaders of the antitrust bar, people who are really doing cutting-edge matters, who are really involved in the major matters, have been active in the section. So the section has been blessed with a lot of people that are just very talented, and I think the section has uniquely benefited from the relationship with the section and the Federal Trade Commission and the Department of Justice. And no other section has that relationship where the heads of those two organizations sit as members of the section's council. No one else in the ABA. So coming out of that and coming onto the Board of Governors, which is a lot more diverse, and doesn't have that same concentration of expertise and deals with a lot more financial, administrative, non-legal content matters, was a real change, and frankly one that I didn't particularly enjoy. So, I mean, one of the first things that happened when I got up there was a big issue over ABA employee pensions, and that's certainly an important subject, and certainly concerned about that issue, but not why I'm active in the ABA. So it was an interesting 3 years. It was an interest. I served on the finance committee, and also spent the last year was on the oversight of the ABA investments, so in addition to the finance committee.
How do you think participation in the section changed you as an antitrust lawyer and affected your career?
What I started with, I think that I've learned a lot. I've worked with a lot of different people on monographs, publications, and came to see different points of view, came to understand differences in how people do. So, you can be in your own isolation, but the section doesn't permit you to do that. So, I've come to learn there's different ways to approach how you do a second request, how you approach the government in a merger investigation, and there's no one size fits all. And I think that while I think I've given something, I think I've gotten a lot more back, and I think it did make me a better lawyer. However good that is, I think being a member of the section and being active in this section made me better.
Well, one of the things that I treasured the section for are the friendships. And I remember going to your children's bar and bat mitzvah,
right,
along with probably 10 other former and future chairs of the ABA antitrust section.
It is nice. I can't say that I went to Matt's bar and bar mitzvah, but I went to your son's high school lacrosse games. So, and we should reveal here that your husband Gary and I are golfing buddies. So at the same club.
Our families are very good friends.
Right, and we've traveled together, etc. So, everyone who's watching this, the section truly is unique, and you do get lifelong friends, which are really cherished. And my wife Lois is very fond of you and Gary. So.
Well, and that's been one of the real treasures for us
yes,
in all of this. Are there any closing thoughts you've got about your career in the section and your antitrust career? And advice you'd give younger lawyers, other than join the section?
Okay, well, the younger lawyers thing, I have to tell a story about you now. So one of the great things about the section is it's always reaching out to people. And Jan and I were asked for a number of years to do little half-hour sort of talks to sometimes law students, sometimes even college students, like on why you should get active in the ABA and why you should get into law. And one of the points that Jan always made was that really the section in the law now is not gender discriminatory, and points out that she spent a lot of her career working on munitions, aircraft carriers, and big tanks and things like that. And she's fond of pointing out to people that because of clients, I've spent a lot of my time on women's undergarments, shoes, and cosmetics. I litigated that for 12 years. So.
Well, I think the point at which you were most jealous of me was when I was advising Portia.
I know, that hurt. I still to this day, I admit my jealousy up front and honestly. So tell them I've bought 4. I'm loyal if you ever have a conflict.
If you ever need help.
And as a matter of fact, don't tell this to Jones Day, but I don't even have to charge them.
I definitely won't tell that to Jones Day.
But I think everything we've talked about. There's been friendships that you met for life. We had dinner last night, and it was just great seeing everyone with the past chair's dinner. There is the learning that you get from the section, and there's the opportunity to become involved in part of something. But like any institution built by and of human beings, it's not perfect. There are flaws to it, but by and large, it's really a merit-based good organization that I was talking to one of our young associates today and telling her that she really had to get active, and if she needed, I would actually I said that Kathy Fenton, as you know, one of my partners and a later chair of the section, would be glad to help her get active.
You no longer have to apply.
Right, you no longer have to apply. You can just sign up. Isn't that a wonderful improvement?
Online.
Online, right.
You can sign up online and then you just show up.
Right, you do. So, and we have in our firm, like your firm, a lot of people that are active in the section, and I take some pride in that because I think the Jones Day has been very supportive of the section, and I think that's benefited Jones Day. So, it's a chance to work with a lot of people that you otherwise wouldn't work with, and to learn from a lot of people that you otherwise wouldn't have that opportunity. So.
And I think an opportunity to learn from things you might not otherwise do because a client hasn't asked you to do it yet.
Correct. Correct.
And the policy issues, I think, are very special because you get the opportunity to try to shape the development of policy.
Yeah, I mean, for example, when you and I were chair, we had issues about the criminal fines and the jail terms that are associated with criminal price fixing, antitrust violations. There's been a lot of issues about jurisdiction over foreign commerce, and I think those are interesting questions that not only raise antitrust questions, but raise international law, comity, COMITY, and other issues that truthfully I don't think in the practice you would normally get involved in as much. And I do think that it does get you involved in thinking about issues in a broader way, and in a way that as a practitioner where you're more nuts and bolts, you want to have what's the role of antitrust in society, in doing some of the healthcare things. Society has different goals, and I do believe that it's important that everyone have access to healthcare. But is antitrust the right way to accomplish that, or is antitrust the end game, or is it a means, and how you do that? And I think that those are issues that in ordinary practice you wouldn't think about or get into. And
it's a great opportunity.
It's a great opportunity. Section is wonderful. I hope everyone who has a chance gets active in it, like you and I got a chance to. And I hope the section continues to be the type of organization that they'll put up with people like at least me.
Well, they keep giving us free dues. Thank you very much, Phil.
Thank you, Jan.
It's been a pleasure.
Same here. Thank you.